Welcome to Win with the Law with your host, Gary Newland. In the Win with the Law podcast, your host, Gary Newland, partner at Newland & Newland LLP, invites guests who are experts in the personal injury law arena and other areas of law of interest to discuss topics relevant to the general public. You can find this show on all the major platforms, including YouTube, LinkedIn, Facebook, Apple Podcasts, Spotify, and on our website, newlandlaw.com. Now here's the host of Win with the Law, Gary Newland.
Hello, welcome to Winning with the Law, the podcast where we dive deep into the world of law and learn from the experiences of the finest lawyers in the law. I'm your host, Gary Newland. For those of you who do not know me, I'm a trial lawyer at the law firm of Newland & Newland LLP. And today we have a special guest with us, Attorney George Sachs. With years of experience in the legal field, George has handled numerous cases and has a wealth of knowledge to share. In this episode, we'll be discussing his career, journey, and exploring the legal issues of venue. Venue is the location where a lawsuit is filed. There are often options as to what county a case can be filed in within a state. Some cases can be filed in different states, and sometimes state court can be a choice over federal court options. Other times, your lawyer may have only one option based on the law. Venue can make a big difference and actually impact the outcome of a case. So without further ado, let's jump right into it. How are you today, George?
Gary, thank you so much for having me. I'm fine, and I really appreciate the opportunity to share with your audience the things that are so important to you and I as trial lawyers.
Thank you for being here. And can you give us a brief overview of your career as an attorney?
Oh my gosh. Well, first of all, we all know that I'm quote a senior citizen. So first 10 years of my practice was general practice, anything that needed attention. But then when I had a big enough inventory or following, I was able to solely concentrate on personal injury, medical malpractice, and I do a little civil rights work.
Nice.
And I've done that for a number of decades. And most of my work is here in Illinois, but I've also had the occasion to do cases in Tennessee. And with co-counsel right now, I'm actually involved in a major case out in Wyoming. So happy to be
George, here. Thank you. You know, George, you're a mentor of mine, and I realize you have had a mentor in the legal community. Who was that?
Well, I was very fortunate. His name was Leonard M. Ring. And Leonard was one of the founders of the Association of Trial Lawyers of America. They're now known as the Association. They've got a different acronym right now, but they are one of the leading and earliest organizations on a national basis to advocate for jury trial, for accessibility to the courts for people who are injured, and for fair legislation to make access and the opportunity to have your case heard available for the public.
George, can you share with us what initially drew you to the legal profession?
Wow. Okay. So I was actually a policeman at one time in Chicago. And every time I went to court, instead of just standing there waiting for everything to happen, oftentimes I'd raise my hand and say to the judge, "Can I say something as a friend of the court?" The lawyers would turn around and look at me like, "What's this policeman doing?" And once I was part of the dialogue, I knew then that I wanted to be an attorney. So I finished my undergrad, and I went to law school, and that's how I became an attorney. And I appreciate both of those jobs.
Now, George, when we talked about you appearing on the podcast today, we thought venue was an important aspect that we should discuss because it really can impact the case. Do you agree?
Oh, absolutely. Not only can it impact the case in subtle ways, or even more than subtle ways, it can actually determine the final outcome of the case depending on the venue. I know that sounds harsh, but venue can be absolutely the deciding factor in whether there's going to be a recovery for a meritorious plaintiff.
Well, how do you explain, or how can you explain to the listeners what venue really means?
Well, venue for litigation is actually akin to the neighborhood where you live, so to speak. This is where you're going to have your case decided, and you're going to, if it's most of the time it's a jury, and your jury pool and your legal community from which you get your judges, that's going to be very important to how they approach and how they interpret the evidence in the case and the arguments of the lawyers.
What factors are considered when determining the appropriate venue?
Well, first of all, we look at the legal aspects, such as where the event happened. Oftentimes, venue is based on the location of the incident that's the subject of the litigation. Sometimes, when you have multiple parties, there are different considerations to weigh as to where venue should be and where it's the most appropriate. And that often becomes a question where it's a motion to the judge, and he or she is allowed to use a great deal of discretion in determining where venue should be. So venue is really actually where you're going to do your work, where you're going to try your case, and where you're going to entrust this case to a jury drawn from the local population.
Can sometimes lawyers have options of filing in federal court or state court, depending on the facts of the case?
Absolutely. Not only the facts, but also the law. There are some causes of action, federal causes of action, that can be filed in state courts. On the other hand, state causes of action where there is complete diversity, in other words, you only have a plaintiff or a defendant, or if you have multiple, but as long as none of them are also from the state where you want to file your case, such as here in Illinois, the Northern District, if you have plaintiffs, they live here in Illinois, you have somebody from out of state that was here and they happen to be involved in an auto accident, and you can have that case brought here in Illinois, but there's also an argument to be made that because this person, the defendant, is from out of state, that it may unduly prejudice them as to the location, the interpretation of the law. And so those cases can then be removed, taken from state court up to federal court and tried there if the local federal rules as to damages and to parties permits it. And it's often done by people who are on the defense side of the case, because federal court is often more favorable for the defense. Not always, but it's a venue where the insurance companies and the regular defense attorneys and their firms are much more comfortable, feel they have somewhat of an edge by going to federal court, because it's often not as expeditious as state court, and they often bifurcate the cases as to liability and then retry them as to damages. It really stretches out the process and makes it more problematical.
George, how has venue impacted cases you've dealt with in your career?
Well, venue has both helped me, and it's also been a very difficult situation that has caused some major cases to unfortunately not be successful for my clients. And two of them that come to mind that are really ones that have been quite impactful and quite significant for me was one that, believe it or not, it started in 2004. This involved a lady who was a teacher. By the way, I talked to the families and have permission to talk in detail about these cases today. This isn't just me gratuitously telling stories here. So the families know that we're going to be discussing this, and they gave their approval. So this person was a teacher at Deerfield High School, the northern suburb of Chicago, where she was a teacher that specialized in gifted students. And her family was absolutely wonderful. She had a great husband, two little kids that were just adorable, and one older daughter. So they were down in southern Illinois with the older daughter going to visit Western Illinois University, and that's in McDonough County. That's quite a ways downstate. And unfortunately, one of the police officers was chasing a suspected drunk driver, but it was on a Friday night in school. The university was in session, and this was an area where the normal speed limit was about 45 miles an hour. Well, the policeman, for whatever reason, to my interpretation, and eventually the courts, didn't use appropriate care and was actually reckless in a sense, was reckless, absolutely, and was approaching that intersection at approximately 100 miles an hour. And 100 miles an hour versus 45 miles an hour is magnitudes by magnitudes a different situation. So the girl who was going to visit Western starts to make a left-hand turn driving at one of those caravans, like all families have out in the suburbs and stuff, quite common. And the police hit them broadside, rolled the van several times, killed the mother, injured the daughter who was sitting in the passenger seat and severely injured the passenger in the rear seat. That case originally was filed in Lake County, Illinois by the passenger in the rear seat. And they brought suit against my client, meaning the driver, the daughter, and against the Sheriff's Department of McDonough County. Well, McDonough County, since they faced the liability here, wanted desperately to have this case brought back to downstate Illinois.
Are you saying, George, they might have thought that more favorable venue for them?
Oh, absolutely. It's their people. That whole county, by the way, has a full-time population of approximately 20,000 people. When that school, when Western Illinois University is in session, it brings the county up to 40,000 people. So when you have 20,000 people in a county, it's quite understandable that there's the people, directly, indirectly, or even on a third level, everybody's kind of connected and knows each other. So it's where there's a strong sense of localism. So what happened was we fought the battle up here in Lake County, and then one of the defendants, so they moved to take it downstate. The trial judge said, no, we have people that were injured who live here in Lake County. We have a Lake County plaintiff. We have a Lake County defendant. It's appropriate to keep the case here. Defendants, meaning the county, McDonough County, took it up to the appellate court, and the appellate court granted that motion based on two things. Number one of the defendants who lived in Lake County was dismissed during the pendency, during the time the case was pending. And number two, that defendant that was left was a municipality, a city, a governmental entity. And there's a provision in the Illinois Civil Practice Act that if a defendant is dismissed during the case and somebody brings a motion for a change of venue, that the trial judge then has the right to rule on that motion and transfer that case if it's appropriate. The other thing that argued strongly in favor of the transfer was that there's a provision in the law that if it's a municipality, they have the venue for that case is supposed to be where that municipality is located.
So the case gets transferred downstate.
Or it got transferred downstate after having been litigated and just run discovery and done a bunch of work up here for about a year, almost a year and a half. It then got taken downstate. And then we started our journey down there. This case eventually went to trial in 2012. And the judge that was signed was not receptive to any of our arguments or our offers of settlement. We did not necessarily we weren't trying to make this a case where it was all about the money. What we really wanted was changes in policy. We wanted them to acknowledge their responsibility and to pay a fair amount toward the medical bills and for the loss of the life of the mother. The trial judge, although he held pre-trial conferences, was not an effective advocate for getting a settlement. So the county drew it out. We tried the case. During the case, I was the lead attorney on that. And unfortunately, the trial judge was less than gracious. I would stand there and be talking directly to the court, and he would stop the proceedings and say, Mr. Sachs, you're blocking the view of the jury. And I go, oh, I'm sorry, Your Honor. And it really set a tone where the jury saw that the court was not particularly respectful of me and wasn't particularly impressed with our arguments. And the worst thing that happened was that the judge allowed the admission of certain evidence that was extremely prejudicial as to a video that showed purportedly a line of sight, meaning what my person saw sitting at the steering wheel. And therefore, they argued that our person, our driver, was at fault for the accident. Well, the circumstances of that video were so different than the actual circumstances of the collision and the death of one of our clients that the jury wasn't given a fair perspective on the facts of the event or how it really happened.
Okay, George, let me ask you a question.
Please do, Gary. Go ahead.
Is this just a lawyer frustrated at the outcome that didn't go his way, or
absolutely
what
not.
evidence do you have that it just wasn't a bad day?
Well, first of all the interactions with the judge, but that's subjective. But at the end of the day, got the appellate court to reverse it, and they reversed it based on my argument that evidence was so prejudicial that the plaintiffs did not in any way get a fair trial. That's the appellate court's decision on it. And eventually on the retrial.
Well, wait, is that a common thing for someone to get a new trial?
No, the presumption is normally that usually trials are affirmed unless there's a significant material error committed by the court or one of the parties that is likely to affect the outcome of the case. And the court was quite clear that this was just totally inappropriate. And therefore, when the case was retried in 2017, the jury, after having been treated according to the directions of the appellate court, brought back a verdict for $4.1 million.
Now, George,
go ahead, Gary.
This is an interesting issue with this case, but didn't it get sent back down to the same judge that had the adverse rulings in the initial trial?
Absolutely, but that judge was admonished and instructed by the appellate court as to what he should do and not do with regard to certain crucial evidentiary matters, and he really had no choice but to follow the appellate court's directions.
So then you retried the case and got approximately around $4.5 million. Is that right?
4.1. What I did is I then put together a team of local attorneys. It also turns out that I did not want my presence as a upstate Chicago attorney being used or influencing how they viewed the evidence of the case. So I thought it was more appropriate, given the culture, given the physical location, to put together a litigation team, not involving me directly, but I put them all together, and I had them retry the case, and they brought back a verdict of $4.1 million on the same proofs, the same evidence.
Now, it's my understanding, I was reading the record, George, and the judge didn't agree with the ruling of the jury, did he?
Oh, absolutely not. It ended up going up on appeal again, and the appellate court said, no, not only did you get a fair and square verdict, we're awarding you interest for the time that you have not been paid while this thing was pending on appeal. But so what happened here?
The jury came back with a $4.1 million verdict in your favor. Mm-hmm. And then didn't the judge say that he wasn't even going to allow the jury judgment to be entered and that the defendant was not guilty? Is it something similar to that happen? That part of it, I have to confess that detail I don't remember. I remember procedurally where we were at, but that does not sound impossible. This judge was very upset that his mandate, his view of the evidence was not shared by the appellate court. And when it went back to the appellate court was not very happy that the judge did not follow literally and in spirit their instructions they provided earlier. So essentially what happened was venue, you feel, may have shaped the problems you had with this case and caused it to go on longer than perhaps it needed to?
Oh, absolutely. And one of the interesting things was this trial judge was an associate judge, not a full circuit judge who are elected. Their associates are appointed by the judges. This associate judge was designated as a special judge for this case. Normally, the case will come back from an appellate court. It gets reassigned to a new judge. But because he was specially assigned to the case, the ruling was from the chief judge that he was going to be reassigned to this case. So we were assigned back to the same person who sent us up to the appellate court, and he wasn't happy to see us back in that courtroom. That's what my team reported.
Now, George, I know you, and I know how you care about your clients. And how did you feel seeing to have your clients, that family, go through that trial twice?
I'll tell you, Gary, at one point they were very dispirited because we literally set up shop down there maybe 3 weeks before the actual trial. We did motions and stuff for maybe 3 years before that. Back and forth, I would travel from Chicago down there and stay for a day or two so I would have rest when I went into the courtroom. They were exhausted. They couldn't believe what the court did. And I had to talk to my clients and reassure them how much I cared about that case. And when I did, they said, all right, let's appeal it. Let's do the right thing. And that was how we got it appealed, and that was how we got it reversed.
It's a hell of a fight you put forth, George. It's a
Yeah.
hell
Oh,
of a
by the way, it finally resolved and the judgment finally got paid in 2018. So you go from 2004 to 2018. I do not have time for another time for crusade for that in the rest of my life.
George, it's as if justice delayed was almost denied in this case.
Oh, absolutely, Gary. But for the fact that the family was willing to trust me and they were so outraged by what happened to their wife and their mother and what was being alleged that their daughter did or didn't do. It was very, very personal, very traumatic, and it really went to the core of them as individuals and as a family.
George, what I've noticed is these experiences, the human factor. I mean, we lawyers, we talk about appeals, we talk about reversals, but the human factor of the time that goes by and how it affects the family and every aspect of the family, of reliving the incident and having to deal with time off from work and reinitiating these feelings that were horrible. It's just, to me, that's why it's so important to get the right venue. In this case, you did everything you could to keep it in a proper venue. And sometimes the cards aren't there you get stuck with the venue you get stuck with.
Yeah. Gary, I often say, and I mean this, all I want is a level playing field. Leonard Ring used to tell me, George, if you're going to try cases, you're going to lose them. Because I remember one time he lost one, and as a young lawyer, I just couldn't understand how he could accept that. And he said to me, George, if you're going to try cases, you're going to lose some of them. So it wasn't that when you have a death case like this and you've got a family that you work with so closely, yes, it becomes very personal. And you also need to remind yourself that to do your best work, you have to maintain some objectivity and some perspective on it. And now this case turned out well, but my most recent event with venue was a real tragedy. And that was
Can you share that with us, George?
I can. I mean, I don't want to depress you, but what really happened was we had a situation where he was 21 years old, 22 years old, a young man who lives in the southern suburbs, and he was down in Tennessee, Winchester, Tennessee. And he was out on parole for drug violations. He was addicted to drugs, as so many young adults get, and he was out and he was down there visiting his aunt and his girlfriend down there, or one of the friends who ended up becoming a girlfriend down there. And he went out late at night in the girlfriend's car to go over to the 7-Eleven and get something, either cigarettes or something like that. And the police, having seen the car out there at like 1 a.m, they were suspicious. I mean, it's a small town. So the officer put on his lights to pull him over. And the young man, apparently he did not want to go back to prison because he knew he was in violation for even being out of the state of Illinois. So he fled. And they chased him, and he ended up running or falling into a local body of water there. And the police, unfortunately, what happened was the police told him, come on, get back here. And he did what he was told. He turned around and he started to swim back to shore. And then he started to drown, and he begged for help. And the police officers, particularly the officer in charge of the scene, wouldn't do anything to save this boy. They wouldn't throw him a branch. They would not allow anybody to reach out to help him. He died within no more than 12 feet from the shore. And it took him about 3 minutes to drown. And all this was caught on the body cams. And it was just horrific. What happened was that case, we filed it in federal court. I had a lead attorney in Tennessee on the litigation. I was second chair on that one. Unfortunately, the judge it was assigned to was an appointee, one of the last appointees from the prior president, did not have any, the president before Biden, did not have any judicial experience at all, would not rule on any of the motions. In the process of putting on a case, you always have motions to dismiss based on this or that legal principle, motions for extension of time for discovery. This judge would not rule on any of what we call dispositive motions, basically the important motions. And it came to a point where finally we had to file as the plaintiff's a motion for status on those motions because we were due to go to trial within 6 months. We had all these experts. We had taken all these depositions. We had so much time and resources invested. We needed to know whether or not we were going to get rulings on these motions because we didn't want to walk in there on the first day of trial and have the judge go, "Oh, I ruled on the motion for summary judgment. I'm granting it to the defendants. You guys are out of here." If we were going to walk into that before we ended up being there to try that case with all our experts, we needed to know what was going on. And it was only after we filed our motion for status on these other motions, within 3 days, the judge threw the whole case out of court. We were shocked. She wouldn't even give us a hearing in person to talk about it, discuss it, or anything. It was just all done remotely. We appealed the dismissal to the, I think it's the Sixth Circuit. And it turns out that in that circuit, 7 out of the 15 judges are very, very conservative. And they only grant relief about 11% of the time, according to a mediator who was assigned to screen the case and conduct a mediation prior to us being allowed to actually argue the case. The problem was, much like what happened in Illinois, but there's just no way around it in the federal court at all. What happened here, if we would have even won in the appellate court, we go back to the same judge again. Let's say we get to try the case. The jury comes back. Based on her track record, it was quite likely she would have said, "You know what, there's a problem with the verdict. I'm tossing out the verdict. You guys can start all over again. Or I'm going to reverse the verdict of the jury, and I'm going to enter a judgment contrary to the judgment NOV, judgment notwithstanding the verdict." So at some point, we had put in many, many thousands of dollars and time, hundreds of hours, experts. I mean, it was at a point where we just did not make any logical or financial sense to keep going. We had nowhere to go. I said to the clients, it was like being dumped in the middle of a desert. There was no water anywhere. There was no neutral source in that legal system. The way we were dealt the cards, I'm not saying all of them are like that. I'm saying in this particular case with this particular judge. So the best we could do was get the case settled for changing their policies to equip the cars with life-saving equipment like a float and a rope, to do training for their officers. And I think they made a token financial payment, and it did not even cover the cost of the case. But the only thing that was important here was that given what we had, at least we got the policies changed, the equipment changed, and some training. But the family had to take that as being an affirmation and a moral victory, even though it was not a legal victory per se, and any kind of the money that was paid had no reflection on the value of the son that was lost. It was just basically, it was a token payment. But sometimes you just can't go any further. We ran into a brick wall, and that was because of the venue. That court, that appellate court, and the worldview of that young federal judge. But more importantly, not even more importantly, but the biggest indicator to me that things were out of sorts and this wasn't just going to happen with any kind of objectivity, the judge would not rule on the routine motions that need to be decided when you're doing litigation. When you've got to beg the judge for a ruling after a year and a half, that's a pretty sad situation. Does this happen all the time? No. These are war stories where one turned out well on the venue and the other one was a nightmare. Most of them, it's a lot more subtle, and we can work with what we got. I mean, most of the judges are good, and most of the defense people, they'd rather win, so would we, but they're willing to do it on a level playing field. So I'm happy to report that that's not the everyday experience, but venue can be critical. And those are 2 cases where it was.
George, because it can be critical, there's a relatively recent law in Mass Tort where the cases are centered in the jurisdiction where the manufacturer of the product is their primary business location. Okay, so when we file a Mass Tort, those cases get removed to the jurisdiction favorable to the defendant. And this is a recent bit of legislation. It's actually within the past 20 years, and it's changed tort law as far as mass tort goes.
Absolutely.
Because it was created to create a disadvantage to the plaintiffs and advantage the defendants.
Well, Gary, that's very much in tune with how states adjust their laws to encourage corporations to incorporate in their state. And was it the state of Delaware that's the most popular state for corporations to register in? So most of the big corporations you're going to find they either have their primary registration in Delaware or they have a subsidiary that's responsible for the action that you're going to pursue, and that's headquartered in Delaware. And Delaware is a very welcoming and accommodating jurisdiction for corporations, but it's certainly not a fair level playing field for plaintiffs.
No, it's another analogy that would be Illinois. Illinois has a lot of insurance companies because they favor insurance companies legally.
Mm-hmm.
And so they tend to base here, and that's good for jobs, but it's not always good for those that are hurt.
Yeah, not for people that work for a living or people who need a fair hearing and need to have somebody say in a legal context, this person did something wrong and they're responsible for what's happened to you and your family. I agree with you, Gary.
It's interesting. I hear people say that the trial lawyers somehow, have some control over the system, and I don't agree with that. I look at who owns the buildings in major metropolitan areas, and they're not owned by trial lawyers. Those skyscrapers are owned by insurance companies.
Yeah, they are.
Insurance companies are in business to make money, like any business is, but that's the advantage of those that are harmed, and they're pushing legislation all the time, George, to hurt regular Americans for their own profits. That's their goal.
Right.
For the most part, what the trial lawyers try and do is create a more equal battlefield, and that's all they can do.
Couple things, Gary. When I was in law school, one of the favorite sayings of the instructors were that if you don't know the answer to a question, the bank always wins, the insurance company always wins. Why? Because they influence the legislators. And that was, I've been practicing since 1979, so this is not something recently. The other thing is, it's not obvious to the public what's going on because legislation doesn't really mean much to them unless it affects them directly. They don't understand that what gets decided on behalf of large financial institutions and insurance companies has a very, very real effect on the premiums they pay for their car insurance, their houses, but also what's available for them when they have to sue somebody for wrongful behavior. If people can't get a fair hearing, there's something wrong with the system.
Everybody should be entitled to their day.
I believe, absolutely. Yeah. I have to tell you, and you and I have tried cases together too. It's really important to have a jury that doesn't have a preconceived notion of what should be done, actually listen to the evidence, talk about it, debate it, and make a decision. It's not easy, but it's really the thing that has kept our system functioning for generations. And now, with all the digital stuff and after COVID, people are very hesitant about interacting and about renewing their in-person activities. But that's the activities that keep us going as a country and as a community. That's what gives other people their humanity when they interact with other human beings who aren't exactly the same as themselves. But I have to tell you this, I wouldn't trade this for anything. And I certainly hope that fairness becomes a value that we all can share and talk about and even agree to disagree. But we shouldn't demonize anybody. Otherwise, we can never have a dialogue. Thanks, Gary. I really appreciate it.
George, it was an honor to have you on the show today, and I hope to have you back again someday.
Anytime, Gary. I love working with you, and I really feel honored to be included today. Thank you.
Thank you.
You've been tuning into Win with the Law with your host, Gary Newland. You can find this show on all the major platforms, including YouTube, LinkedIn, Facebook, Apple Podcasts, Spotify, and on our website, newlandlaw.com. Thank you for your positive reviews, comments, questions, and for sharing this show with others.